Hey there, it's Rob Ryder. Again, this is getting to be a habit, but I kind of had to do this today because I won't have time over the next number of days, and I'm trying to help a few people that have court cases that continually email me. I don't have an answer for you, first of all. If you're emailing me for an answer to your court case, I don't have an answer. I'm looking for one. But what I can show you is what I'm doing in a court case with somebody, and I try to share it every time in a video. It's just here recently, it's all been about election stuff. But not so long ago, in fact, let's just take a quick look. That would have been, how about right here? Esquires are enemies of the United States, right? That would have been 2 months ago. Here it is. No. Responsive pleadings versus motion practice, right? Which is the last thing I tried in a lady's case out in California. And then we had to wait for stuff to happen. And then, there's been a lot of stuff happening in the world since then. And they didn't handle that paper the way, that I was hoping it would be called. They didn't call it a responsive pleading. They just called it a response. So they didn't even call it an answer. And okay, well, what else can we try, right? And but if you wanted to know where this started, what I'm talking about, if you go back to this responsive pleadings versus motion practice, it would give you some idea of the court case I'm talking about. Actually, this one here, the fly on the wall knows all. This picture here, this is of the register of action of that particular case. So obviously I was talking about it there also. So, I don't need to do your court case. I don't need to do anybody's court case for them. You need to pay attention to what I'm saying now. And if this would work for who I'm doing it for, well, it would work for you because this is the common cause answer, right? All your little problems, everybody's own little specific problem really isn't the problem. It's a symptom of the problem. And the problem is more underlying, which is, these people aren't who they say they are because they don't have a proper oath of office. They didn't take the oath in 4 U.S.C. 101. But they're still acting like judges and they're taking people's property. And, there's the court and they're taking you there. And if you don't do something, they're going to come get your property. So you might as well go tell them something. And if you're going to tell them anything, well, tell them the truth. Right? And so a lot of the stuff I've done for years, I don't have nothing to do with courts, right? So I'm really not a court expert. I don't know anything about putting paperwork into court. I don't know what the proper terminology is. I just know the little parts I read and then try to do something with. And that's kind of why we're here today, because here recently I had read when I was, so one of the things I've been telling people to do is to take the Army Sworn Statement form, right? DD form 2823, I think it is. It's an Army Sworn Statement form. I'll show it before the video's over. And I said, well, if we were to take this and fill it out, have it done properly from the top to the bottom, everything done right, then the Army would say, well, that's a sworn statement. Well, that much I know for sure. And, so then we should be putting our statement on a sworn statement on this form and then submit it into our court case or, whatever we would need it for. Well, it turns out that doing that specifically properly done could be what's a deposition of yourself. And then you get into this thing about depositions, right? Where as the defendant, you can have a deposition on the plaintiff or on, now they don't really specify how far that could go. And so my thought was, well, in that case, have a deposition on the plaintiff's attorney and have him answer, right? Because the plaintiff really doesn't exist in all of these cases. I don't care if it's a criminal case or a civil case. In a criminal case here, for Michigan, they would say that the plaintiff is state of Michigan. And as I've been showing in my videos here recently, state of whatever isn't, that's not the name of the state, right? The name of the state is just Michigan, not state of Michigan. So Michigan is a state and its name is Michigan. Its name is not state of Michigan. And yet I showed in, my recent videos that that was the name that state of Texas that tried to take a case to the Supreme Court. And the Supreme Court said state of Texas doesn't have any standing. They didn't say Texas didn't have any standing, but Texas didn't bring the case. And they didn't say United States didn't have any standing, but United States wasn't the plaintiff. In fact, they weren't even asked to join in on that one. But a few earlier, the Supreme Court had asked the special request, basically, to the Solicitor General he wanted to jump in on this particular case, and there was, United States as a party. Well, if the United States can be a party, then the United States can be a plaintiff, which is what should be being done in the big world of the election fraud, right? But we're going to leave that aside. We're going to go to, well, what about me? What about my problem? And that was the thing. I'm helping Christina in California, who's got a problem for a debt collection. And so debt collection, you can call it foreclosure or debt collection or tax thing or whatever. They're all the same. Somebody's coming to get money from you. They come to collect. And in all of those cases, when they take you to court, one of the things you could do besides a deposition under discovery is you could do this thing called a request for admission. And a request for admission is just simple yes or no questions, right, that you send to the other party. Now, this is specifically to a party. So if there's multiple defendants, I guess you could send one if you're the defendant to another defendant. But I'm always thinking about sending it to the plaintiff, and I'm never thinking about sending it to a defendant because I don't believe we should be in court as plaintiffs, right? The United States should be the plaintiff. I'm just talking for the United States, but it's the thing its law has been violated, not mine. But in these, civil cases, people are coming after you personally, and that's a different story. So what I'm, proposing is, well, then we ask the plaintiff to confess to their sins under this form of discovery that's called request for admissions. As it turns out, request for admissions is evidence, and that's what we're looking for. Got to have evidence. And so if you ask questions to the other side and they don't answer them, then whatever you ask the question of, depending on how you phrase the question, is going to be, found true. All right, so it's just true or false, yes or no. Let your yea be yea, let your nay be nay. So you got to be careful how you write your question. And that would be the reason, well, don't have many questions and just make them all the same and start with the things that really matter, not what they say that you're doing wrong, but start with the things they're doing wrong. And we'll get into all that in just a minute. So Rob Ryder's email is courtofrecord@aol.com. My phone number is 616-712-6179. And again, I'm doing this video today for the people who have been contacting me by email or trying to call me saying they have court case problems. They want me to fix them for them. Right? I don't really have the answers, right? So I'm going to be concentrating on this video on doing it for a civil case, but there's no reason you can't do a request for admission in a criminal case, and you can always do a deposition in a criminal case. Right? And so the thing with a deposition is, whether you have it done to yourself or somebody else, you have to go to somebody who's been certified by the court to do the deposition. All right? Now, it can be a written deposition or it can be an oral deposition. But either way, there has to be an officer appointed by the court to, be the one doing the deposition. And then they take the papers and they submit them to the court. Right? So on an affidavit, you get the affidavit done, you take the papers and put them into the clerk of the court's office. Well, that's not the same as an officer of the court taking them and filing them into the court. And that's the difference between a deposition being evidence, foolproof evidence, because it's a public record or official record that was created by a court officer, compared to a deposition, which is never going to be any better than hearsay evidence unless you have it authenticated. Right? And you look at if you were to look at the affidavits that Trump's attorneys are putting in on this election fraud, they all say they're affidavits. Right? Well, an affidavit by definition is an oath. It's not evidence. It's not testimony. Testimony is evidence. It's an oath. Well, then, that's not evidence. It's an oath. So you can't put in an affidavit. Now, you may have an affidavit as part of your evidence because, that's the way it's done, and that's how it's on this Army sworn statement form. In fact, let me get that real quick, just to get that out of the way. Okay, so here's the Army sworn statement form, and there's nothing magical about this form. It's just, in my mind, this will have been done correctly, right? It will be a correctly created form. The Army likes to do things properly, right? So this form is properly created. It's just, will it be properly completed, right? But this is the sworn statement part. I put your name in, want to make the following statement under oath. You blah, 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 do your thing. If you need more pages, you got more pages. You got initial, you got to, tell the number of pages until you get to the bottom. And, here on this form, the affidavit is at the bottom. And it's just you saying that, the statement is yours. And you understand the contents and that it's true. And you've initialed any corrections, initialed each page. You've done it freely, yada, yada, yada. And you got to do it before an officer and 2 witnesses. Well, the person that would be doing this in the military is a commissioned officer, right? They have a commission to do this. And so when he was doing it, he'd be sitting in a room with a gold fringe flag. Okay, well, my township supervisor has a gold fringe flag. He should be able to do this. And it says in the township laws that he could, but, they haven't. And other people I've asked that are trying to get it done haven't been able to get it done by him. So, I'm not blaming them if they can't do it. What they should say is, look, especially if they're being told by their township attorney, well, you can't do that. Whatever they're telling you. Then pick up the phone and call Homeland Security and say, I'm not allowed to enforce the laws within the jurisdiction I'm supposed to be the township supervisor of. There's something wrong. Please come help me. And we could get past all this shit, right? But until then, it's us out here trying to pierce a hole in the veil. That's all I'm trying to do, and I don't care how I do it. So if I could do it in the sworn statement form, that would be the tool. If I can do it with the request for admission, well, that'll be the tool. So, since I really do put all my time into this, right? So if you could please help me keep the lights on by sending a donation of PayPal to Rob Ryder, ROBBRYDER at AOL.com, or put it in the mail to Robert Allen Retluski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341-8664. Just stop right now and write that down, right? Just stop the film for a minute, write it down. You're not going to miss anything. And I wanted to say, hey, I'm not on social media. I'm not Rob Ryder, although apparently there is one. Somebody sent me something today that had that on there. It's like, well, that's not me. I don't have any social media other than YouTube. What I copy then onto WordPress, which is basically just a link to the video. So, okay, that's enough of the starting stuff. Give me just a second. We'll get rolling here. Okay, just a quick definition of request for admissions. Then I want to spend a minute on what we did to get to this point, and then we'll get into the request for admissions. But a request for admission, sometimes called a request to admit, is a set of statements sent from one litigant to an adversary for the purpose of having the adversary admit or deny to the statements or allegations therein. Requests for admission are part of the discovery process in a civil case. In the U.S. federal court system, they are governed by Rule 36 of the Federal Rules Civil Procedure. And sure enough, go find Rule 36, and there it is. And so, and then every state has it someplace, and right? So it's not hard to find, and that's all it is. This is really simple. You're going to set a set of statements to the other party, and they have to admit or deny to them. So they have to be yes or no styled questions. Okay, so the case I was helping was with Christina out in San Diego, right at the Superior Court of California, County of San Diego. And this is the register of actions, right? They're easy enough to look up. Has the case number, the case title, all sorts of information in here. Who the participants are, right? So, this whole thing here is the name of the plaintiff, not just the part that's uppercase, right? This whole thing, if they're saying that's the participant's name, then that's their name. Well, there is no corporation with that name, right? This is what they do. They put an addition on the name, and they changed it from being what could have been a, proper business into a thing that's pretending to be a proper business. So, unless you could go to the Secretary of State in California and find it listed as a business, just as you see it here, every word is the name, well, then they don't have any authority in the state of California to do business. This isn't that difficult. On top of that, right, so that's the company that's saying that Christina, which is Francis, Christina, so this isn't her name. This is the name of her business, right? Your name doesn't have a comma in it, even if they want to put it backwards, right? This is how they identify. They're talking about your legal person compared to your natural person. So Frances Christina, in any form of her name, never signed a contract with this company, or even the company without that on there, or the other company signed the contract also. And it's the same when you go to get a loan from the bank for a mortgage. The bank that you think you're doing business with, they never sign a contract with you. So they never made you a loan. All there is an application. And even it isn't filled out completely, right? So the whole system that we're in is based on errors and omissions and records and not knowing what to do with them. And, so it's just wrong. Well, this is what's going on. And the last thing we put on is this. It was supposed to be a responsive pleading, which is another entity out of the federal rules that you can do. But they called it a response, and they put Frances, Christina as the defendant, and so forth and so on. So, but what did that thing say? Because what we put in there, instead of calling it a responsive pleading, maybe we should have called it a deposition and had done it as a deposition, because what we were trying to do is put in basically a sworn statement without using the Army's form. Right? And it said that I, Christina Frances Affiniate, swear that the State Bar of California's member, David Aaron Kaysen, or his imposter, because we're really not sure who's doing it, right? But there is a David Aaron Kaysen with this number on the State Bar, and the guy that's doing this is a guy named David A. Kaysen using that number. So it's either him or somebody pretending to be him, right? I'm not going to blame him until we know who did it, but that's who's doing it. So simulated a legal process by filing in the Superior Court of California, County of San Diego, a summons to the San Diego Superior Court. You caught the difference there, right? He filed a summons into the Superior Court of California, County of San Diego. Oh, well, actually, that was the name of the process, right? But he filed the process in as a summons to the San Diego Superior Court. Yeah, we'll look at it in a second. With the complaint caption, Superior Court of California, San Diego County, North County Division. Let's look at it now so I don't confuse myself or anybody else that doesn't need to be confused. Where are you? So this is what he did. All right, here's the summons. All right, here's Christina Frances, comma, an individual. Right, that's what they're saying her name is. Here it's properly done. There's no comma. It's not Frances, comma, Christina, but that's the way they show it in the court case. And here's the name of the plaintiff. That's exactly the same as it is on the register action, so they didn't change that one. But on this summons, right? So it's to go to the San Diego Superior Court, North County Division, right? But they filed it into the Superior Court of California, County of San Diego. So it wasn't filed into the court where the court case is heard, right? So now this court case, Superior Court of California, County of San Diego, that's where this register action comes from. Right? So Superior Court of California, County of San Diego. Yep, that's the register actions. And Superior Court of California, County of San Diego. Yep, there it is. But the name and address of the court where the summons is, they're talking about is the San Diego Superior Court, Northern County Division. That ain't the same. And we go down and we look at the complaint. The complaint says it's in the Superior Court of California, San Diego County, North County Division. Well, again, it's Superior Court of California, County of San Diego, so it doesn't match, where the case is being filed into, and it doesn't match the name on the summons. So we got 3 different names of courts, right? Now, we can all agree that's wrong, right? That's not how it should be done. And yet, that's, what has Christina in court. So they did all that on behalf of a plaintiff without legal standing in California, right? That long-ass name, it's not registered in California. It can't do business in California. So it doesn't have any legal standing in California. Now, he did it using the alias David A. Kaysen, right? He didn't do it as David Aaron, he did it as David A. Kaysen with that number, resulting in a malicious prosecution under color of law intended to deprive me of my life, liberty, or property. Right? And then it was really just making some statements. David A. Kaysen is not the full legal name of any resident of California, United States. David A. Kaysen is not the name of any California lawyer constitutionally qualified to prosecute for a client in a matter that could adversely affect my life, liberty, or property. Plaintiff, the long-ass name, company, does not have any legal standing in California to sue or be sued. Earl H. Moss III, who's the Superior Court of California County of San Diego judicial officer, right, the hearing officer, is not the full legal name of any resident of California, United States. Right? So this isn't the name that's on anybody's driver's license. Just like, David A. Kaysen isn't the name on anybody's driver's license. That's your identification, right? These people are not properly identifying themselves, and in a time of war, that's, a sign that you're dealing with a spy. So it is my belief that Earl H. Moss III did not execute the federal loyalty oath in 4 U.S.C. 101, required of every state executive officer or judicial officer to satisfy the 6th article of the Constitution of the United States, and as a result, Earl H. Moss III is not constitutionally qualified to judge any matter that could adversely affect my life, liberty, or property. Superior Court of California, County of San Diego is not the Superior Court created by the Article 6 Constitution of the United States, or California Constitution. I am the victim of an unconstitutional color of law simulated legal process prosecuted by a person allegedly licensed as learned in the law for a plaintiff having no legal standing in California before a judicial officer lacking the constitutional authority to deprive my person of life, liberty, or property. My person and property have been damaged by a malicious prosecution and intentional tort of a member of the State Bar of California. I pray the court discharge this proceeding, provide compensation for damages, and other relief the court deems equitable. And put the affidavit at the bottom. And so, again, this was kind of following what the Army did. But instead of doing it this way and filing it ourselves, we probably should have done it as a deposition and filed it into the court, and then had the deposer file it into the court. But as you can see, this is, just making statements, and then, that's my statement, put it in, I swear to it, let's see what he comes back with. Because, I know that these are true. 1, 2, and 3 for sure. 4, yep, I know that, I know there's nobody with that name. Show it to me on a driver's license. And then this one's a belief, and I guess I could have put here too that I believe Superior Court cover my ass better, right? But I don't believe that to be the proper name, so put it on. And, so that would be, instead of filing it as we did, trying to put it in as a responsive pleading to an answer, or as an answer, after an answer was due, we should put it in as evidence, as having ourselves deposed, right? Or not ourselves, but Christina being deposed by the officer appointed by the court. Now, you want to find out who that is, you got to call the court and ask them. Because as a defendant, it's your right to have a deposition. This is all written in the laws, the court rules and statutes to do with discovery in a court case. Okay, and I'm sure you've all seen it before, but I just keep showing it because it's the truth. Right? For United States Code 101. Now, this is the page that you get if you go to the GPO website. So if you Google 4 USC 101 and you see, a link going to the GPO website, you should be able to click on PDF and, get this one-page document. And it will have that little bird up in the corner, which says it's an authenticated copy, right? That this is basically the law in the books today. But as soon as you print this out, it's just hearsay. It's only authenticated while it's on the computer. Right? So, so we've taken this and given it to them. In fact, I just talked to somebody today who did it, and with the prosecutor who came back and said that it was that she was submitting to him statements and interrogatories. Right? So what it wasn't was evidence. right, of a law. This should have been, so what I believe we should be doing is go to the library and have them print this out for you. Now, they may have a different source for 4 USC 101, but say, listen, I need you to print me out a federal law. The law number is 4 USC 101. You could take this in and show it to them, right? But I need it to put into a court case, and I need it as proof that this is a public record. Now, if you go look in a library book, in the front of it will be a seal and a signature. Go get one and say, just like this. I need you to put this on this document that you print out to show that it's a public record. She can't do it on yours because it didn't come from her. It needs to come from the public record. You brought in a private record and you're trying to tell her it's a public record. Now she needs to go to the public record and prove it's a public record and give you a copy that's got a seal on it to prove it's a public record. And then you need to know that that's what that is. What that is that self-authenticating evidence. Satisfies the rules of evidence for Federal Rules of Evidence, Rule 902. Just like a deposition does. An official report or official document is also foolproof evidence, and that's what a deposition would be if you had the deposer depose you and file the paperwork for you. Right? That's why I'm saying that this thing that we did, where we tried to file it, and as a responsive pleading, we should have gone and, maybe had it done as a deposition. But you got to pay for that. So one way you don't have to pay for something is this other thing we're talking about now. Right now we'll get into this other idea where, let's just cover some basics here then, right? So if you go and this is the court rules for Michigan. Every state's going to have some kind of court rules, and there'll be a section on discovery, right? And you'll see it talking about depositions for oral depositions, depositions for written depositions, use of depositions, right? That would all be the thing I was just talking about doing. And then there's interrogatories, which is asking for questions that require, like paragraphs of answers. But then there's this thing called request for admissions. And it says, where did you go? Shoot. Hang on just a second, please. Well, hopefully it doesn't happen anymore. Okay. So where were we? Request for admission. Availability. Within the time for completion of discovery, a party may serve on another party a written request for the admission of the truth of a matter within the scope of MCR 2.302 stated in the request that relates to statements or opinions of facts or the application of the law to a fact, including the genuineness of documents described in the request. Copies of the documents must be served with the request unless they have been or otherwise furnished or made available for inspection and copy. So, you could have them look at any document you want them to look at too, right? And, is it genuine, yes or no? But I don't want to do that. I don't want to have to go look for documents. I just want to ask them some simple questions and make it so that they can't answer, right? If they can't answer, then they've agreed, and then say, well, Judge, they agree, so now give me my relief. But that's all it is, right? It's just asking some questions. Each matter to which a request is made, this is talking about the answer now, is deemed admitted unless within 28 days after service of the request, so you got to serve it just like anything else, or within a shorter or longer time as the court may allow, the party to whom the request is directed serves on the party requesting the admission a written answer or objection addressed to the matter. Unless the court orders a shorter time, a defendant may serve an answer or objection within 42 days after being served with the summons and complaint. And so this is the thing. When they send you a summons and complaint, they're looking for an answer. And if you don't answer, then you've agreed to whatever it is they said. Right? They're tying this idea of you giving an answer to a complaint to being you giving an answer to a frickin' request for admission. So, I'm thinking if they're not doing it already, that's what this is saying it could be used for. right? But because they're not really doing any of this stuff right. I don't know that that's what they're doing, but that's what the rule says it's supposed to be used for. But these people don't do anything the rules say. So, what can I tell you? Um, Now, the same thing is in Rule 36, right? So this is federal now. A party may serve on any other party a written request to admit for purposes of pending action only the truth of any matters within the scope of Rule 26B relating to the facts, the application of law to a fact, or opinions about either, and the genuineness of any described documents. Each matter must be separately stated. A request to admit the genuineness of a document must be accompanied by a copy of a document unless it is or has been otherwise furnished or made available for inspection and copying. Okay, so it has to be a yes or no question, and it can't be a compound question. It has to be one question, one answer, one question, one answer. Let your yay be yay, let your nay be nay, and understand if they don't answer, then however you've written the question, they've agreed that that's the answer. Now we just need to write them some questions and get it properly served. And they never tell you who the plaintiff's address is, right? So like in a criminal case, it's just state of Michigan. So, but the state of Michigan, its attorney is whoever the prosecutor is. So you serve it on the prosecutor, right? And they have to answer. They have to get an answer for the state. If it's a living person, well, then they have to answer. So now, for instance, in this case with Christina, the plaintiff doesn't really exist. So there's really no way for the plaintiff to answer. Same with state of Michigan. It doesn't exist. I don't see how they can answer. But the way to find out is to put one in and see what happens. So I'm just advocating somebody go put these things in and see what happens. And I'll show you one that we're doing to give you an idea how it could be done. And then leave it up to you. Go ahead and do it. So let me show you what we did in Christina's case, right? Because it was California. I'm not really showing you any California law because it isn't written all that plainly. But it doesn't have to be, right? We'll just you get the idea of what you can do, right? And what I will say, before I forget, where are you? Request for admission. Right, if you went to YouTube, request for admission, you'll see this introductory to discovery, right? This is really the form I'm going to show you now that's used in California, and this guy does a good job about explaining it. So, you don't have to don't take what I'm saying to be the answer. Go do some more research and make it work for you. But if it works, please come back and tell me so I can tell other people. So here we go, right? So what we're going to do now is, let me find this one law first. Hang on a second. There's one more thing. Okay, so this is, because what I'm going to be showing you is how they do it in California. So we should look at a little California law for a second. And this is California Code of Civil Procedure, Article 1, Request for Admission. Out of the Code of Civil Procedure, Section 2033.010 to 2033.080. Any party may obtain discovery within the scope delimited in Chapter 2 and 3 and subject to the restrictions of 5 by a written request that any other party to the action admit the genuineness or of a specified document or the truth of a specified matters or fact, opinion relating to the fact or application of law to the fact. The request for admission may be related or may relate to a matter that is in controversy between the parties. A defendant may make requests for admissions by a party without leave of court at any time, right? You don't have to, ask permission of the court. You just need to serve the questions on the plaintiff. Now, as far as plaintiffs, that's not my gig. Maybe some other day, but right now I just want to get a defendant to win. One step at a time. So that's the thing that needs to be done, right? And they have a form they use for it in California. That is the DISC 020, right? This is a request for admissions form. And so, because it showed in under depositions when I was looking at the law, and you need to sometimes by motion ask for the deposition. It showed that if you're doing it for yourself, you should call yourself pro per, right? So Christina Francis in pro per, and her address, right? She's the attorney for the party basically, because the party is her business name, right? Francis, Christina. That's who the defendant is, right? And I didn't have all this information, but she did. This is Superior Court of California, County of San Diego. Finished putting in the address, whatever it is, right? What's the short title? Well, that I took this right off of the Register of Actions because that's what they called it with the case title, right? I don't know why it says image down there, but if it's good enough for the court, it's good enough for me. Right, and then request for admission, truth of facts, requesting parties the defendant and the answering parties the plaintiff. Right, this is set one. If you had already done one, you put set two, and you just however many you've done, and the case number. So now you don't have to use this form, but you may have to have this kind of information. So it would be good to use this as the guide, and then watch the video I showed you that this other guy put out, because that's the form he's using, right? And you'll figure out what even if you put it on your own form, what to use. You don't have to use the form, right? But there you are. It has the instructions on it. Requests for admission are written requests by a party to an action requiring that the other party to the action either admit or deny under oath, the truth of certain facts or the genuineness of certain documents. For information on timing, the number of admissions, blah, 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 the answering party should consider carefully whether to admit or deny the truth of facts or genuineness of documents. When limited exceptions, an answering party will not be allowed to change an answer to a request for admission. Keep on going. I don't want to read all that. Anyways, and then it gets to here. Answers to requests for admission must be given under oath. The answering party should use the following language at the end of their request. I declare, under penalty of perjury, under laws of the state of California, that the foregoing answers are true and correct. So this isn't what you fill out if you're the one sending this, out to be done. This is just showing whoever answers what to kind of put at the bottom of their answer. They have to swear to it. Right? You're going to get the plaintiff to swear to an answer. And I want to see State of Michigan sign the paper. Or, in this case, this Brixmore Felicity. Who is their officer that's going to sign and swear to the answer? Okay, so request for admission. You are requested within 30 days after service or within 5 days after service in an unlawful detainer action, which, we could say that it is. Say this is unlawful detainer. You're detaining her property. Of this request for admission that each of the following facts is true. All right, so here we go. What did I ask? Now, this is where you got to decide what you're going to ask them, right? So the first one, the entire name of the plaintiff is Brixmore Felicity Town Center, LLC, a Delaware Limited Liability Company. Now, that entity with that name has to say yes or no that that's its name. If it doesn't say that's its name, if it doesn't answer me, then that's its name. Right? That is the name of the plaintiff. Unless the plaintiff objects or gives me some other answer and says no. They don't have to tell me what it is, but they got to tell me no. All right, well, that's all the room on this particular one. And so continuing on, because there's a continuation page, right, with a few more things on there. But your other choice is to, give them some documents. So here you go. Check, check. And then this is where you sign, or full legal name, and then sign over here. But that's it, right? That's the form to do a request for admission. So you don't have to do a motion leave or anything else. You just got to fill this out with your attachment and file it on the other party and, put it in the court and tell them that you filed it on the other party. So this is the first thing I would, so if you have, this is a foreclosure or any kind of civil case, right? First of all, make him tell you what the name of the plaintiff is, right? That the entire name of the plaintiff is, now, I could have said full legal name of the plaintiff is, maybe that's what I should have said, but I was running out of room at the time. I think that's probably what it was. Brixmore Felicity Town Center, just the way it shows on the document, right? Just the way the bank shows who's ever supposed to be foreclosing on you, right? Put that in there. Now, people are going to say, well, what if my case is already closed? I don't know. Just go do it anyways. Just go fucking file it and see what happens. See if somebody pays attention to it. This is how easy it is. Don't ask me what's going to happen. You go find out. You tell me what happens. So here's the attachment then, right? I put the Brixmore, basically the same names at the top as what was on there. And request of admission. Set number 1. So a few more questions. Oh, I didn't number these. I should have numbered them. But I didn't, so that may cause a problem. Hopefully not. I get a hold of Christina. She may have already filed this. But if she didn't, right? 1, 2, 3, 4, 5. So 1, plaintiff did not sign, seal, and deliver a bilateral business contract with defendant. Right? Whoever the plaintiff is didn't sign any contract with the defendant. Yes or no? Right? Well, if they don't answer, then yes, they did not sign a contract. Plaintiff is not a business entity registered with the California Secretary of State. This is the reason I have these words capitalized. It said somewhere if the words you're using have a particular definition, then you need to make them uppercase. Right? So I'm talking about a particular plaintiff and a particular defendant, right? And a particular California Secretary of State. These aren't common names. These are, proper names of things, or at least to do with this case. That's my interpretation of what they meant, right? So plaintiff is not a business entity registered with the California Secretary of State. If they don't answer, then they agree they're not registered with the Secretary of State. Plaintiff does not have legal standing to sue or be sued in California, United States. Right? They don't answer, well, then they don't have legal standing. Plaintiff is a conspirator in the malicious prosecution of defendant. They don't answer that they agree. Yes, I agree. I'm conspiring in a malicious prosecution of the defendant. And finally, attorneys for plaintiff is plaintiff's malicious prosecution conspirator. So you'll get, without them answering, you'll get them to agree that the attorney for the plaintiff was conspiring with the plaintiff to maliciously prosecute the defendant. Therefore, the defendant should get damages from their liability insurance, which covers malicious prosecution. Right? So that's all we're trying to establish now, is that they agree with all these. But, so that I've done it. That should have been a 1, 2, 3, 4, 5. Actually, it should have been 2, 3, 4, 5. But you get the idea, right? You're supposed to number each one. And that's all there is to it. Right? So, I wrote this up and sent it to Christina. I said, you got to get it served on the plaintiff. I don't know how you do that stuff, right? Whatever it takes to do it. Go read the section you need to read about how to serve the plaintiff, which is basically sending them a copy and then filing a document that says it's proof of service, that somehow it was served on them, right? So you could have, somebody else mail it for you and just say that they did it, that they put it in the mail. Right? So the idea of it being proof instead of it being a certificate, right? Proof of service. Here's the proof, signed by whoever did it. So, that's all I wanted to show. If you have any kind of court case at all, right, there's no reason you can't do this. And it's just as simple as starting out with whatever the request for admission form is you're going to use, or use a form like this as the vehicle for you to, name the thing that it is you're doing. and make up your own. But all this falls under discovery, right, in a court case. So I'm sure that every state's got some kind of forms already made up for this, or there's something at your law library to use for discovery, right, that would give you the things that you need. So you're just filling in the blanks. But, just so you can see how we did it, or I did it for Christina. Christina Francis is going there in her proper person, right? And here's her address, and she's going there as the attorney of Francis Christina. Now, you may say, well, that means that's an attorney practicing without a license. Well, the court she's going to isn't a state court, so it doesn't matter, right? This is like going to Judge Judy's court, because this guy, the judicial officer, Earl H. Moss, right, judicial officer, he didn't take the oath in 4 U.S.C. 101, so he's not a state judge in any form or fashion, but he could be a Judge Judy, and because you were coerced to going to that court by this attorney, not knowing the difference, who got you to argue the facts instead of arguing the fact that you're in the wrong freaking jurisdiction because the judge doesn't have the proper oath, that's how the court got jurisdiction, because you argued the complaint of the frickin' of the attorney, right? So we're trying to undo that and say, okay, well, if I'm already here and you're saying that I'm in that case, well then, here's my request for admission, and see if that jurisdiction uses requests for admissions. And the only way to find out is to put them in. So I know a lot of people don't want to go into court, think it's wrong to do it in the court and so forth. And yeah, I get all that, but it's easy enough to do, and it doesn't cost any money to do, and it would answer a lot of questions, and it makes them have to do something, and it allows me to tell them again they don't have the oath in 4 U.S.C. 101. You don't have any authority. You're going to hell unless you come tell somebody. That kind of stuff to work on their freaking consciences. So please, go stick something in the window. So, okay, I'm going to leave it there. You get the idea, right? That is what we call a request for admission. It's evidence. It's basically asking the plaintiff to confess to their sins. Because, again, the plaintiff, how is the plaintiff going to sign? He doesn't exist. So just make sure that whatever you write, you're writing it so that, them not answering gives you the answer you're looking for, so you can say, well, then, it's a malicious prosecution. You want them to admit it's a malicious prosecution so you can go collect on their insurance. All right? That's why I'm doing it that way. I want them to admit that it's a malicious prosecution so that then you have evidence to take to their insurance company by whatever that process ends up being. But first, let's get the evidence. Well, very good. You all have a great night now, and be back when I know more. See ya.